The criticism hitting the nation's judiciary seems to be filtering to the ears of the CJN. Hence, she has resolved publicly that she will be doing everything within her capacity to correct the abnormalities we see today in the judiciary.
And found worthy of the prestigious rank of Senior Advocate of Nigeria. However, while this is an occasion for celebration, it is equally important to engage in sober reflection. Although our journey has not been entirely smooth, the challenges we faced have provided us with opportunities to learn and improve. In areas where we have excelled, we will strive to raise the bar. And in those where we have fallen short, we will assess ourselves critically and move forward with renewed determination. That said, the Supreme Court and the entire Nigerian judiciary as a whole have fared well in the past legal year, thanks to the prayers, advice, and support of well-meaning Nigerians. As the new legal year unfolds, we look forward to building a judiciary that will be the pride of Nigerians both at home and abroad. The 2023-2024 legal year, which concluded on Friday, 19 July 2024, was marked by several significant milestones. On Monday, the 26th of February 2024, the Supreme Court made history with the appointment of 11 new justices, marking the first time in recent years that the court reached its full complement. These appointments provided much-needed reinforcement to the 10 justices who had been handling the entire workload of appeals. Shortly after the legal year ended, my predecessor, Honorable Justice Olukayode Ariwola GCON, retired on Thursday, the 22nd of August 2024, having attained the constitutional retirement age of 70 years. I was subsequently appointed in acting capacity on Friday, 23rd August 2024. In the last legal year, the Supreme Court handled 1,124 cases, invoking both its appellate and original jurisdiction. These included 435 civil appeals, 269 civil motions, 219 criminal appeals, 102 criminal motions, 89 criminal appeals, and 10 originating summons. A total of 247 judgments and rulings were delivered, including 74 political cases, 92 civil cases begun by originating summons, and 81 criminal cases. This remarkable success is attributable to the dedication and teamwork of my fellow justices and court staff. The Supreme Court of Nigeria remains one of the busiest in the world, a testament to the upsurge in litigation which has kept our dockets full. Our workload is intense. We work from Monday to Friday, holding daily sittings. Wednesdays are reserved for chamber sitting to consider non-contentious matters, while Fridays are dedicated to delivering judgments and rulings. I am deeply grateful to Almighty God for giving us the strength to accomplish so much. However, I encourage litigants to embrace alternative dispute resolution mechanisms to ease the burden on our courts. The culture of litigating every disagreement and appealing every lost case, no matter how trivial, contributes significantly to the backlog of pending appeals in the Supreme Court and the Court of Appeal. This trajectory is unsustainable for a nation striving for economic development and human capital growth. Educating Nigerians on the benefits of alternate dispute resolution is a collective task for all stakeholders in the justice sector. In this regard, concerted efforts are being made to ensure that the Supreme Court Mediation Center becomes operational to make the desired impact in the new legal year. The Corruption and Financial Crime Cases Trial Monitoring Committee, chaired by Honorable Justice Suleiman Galadima, CFR JSC retired, has been instrumental in expediting the trial of corruption and financial crime cases in the country. Working in collaboration with anti-graft agencies, the committee has facilitated a significant rise in the dispensation of corruption cases, Between the 2nd of January 2024 to 2nd August 2024, the Economic and Financial Crimes Commission, EFCC, with the committee's support, secured 2,387 convictions, while the Independent Corrupt Practices and Other Related Offences Commission, ICPC, filed 54 cases and secured 11 convictions. While holding the judiciary accountable where we fall short, we should also commend the courts in deserving cases for their commendable performance in handling these cases. This is a new dawn and a new era in the Nigerian judiciary. I want to assure my fellow Nigerian citizens that we are committed to working more diligently to improve public perception of the Nigerian judiciary. Over the years, various factors have contributed to the negative image of the judiciary. However, we are determined to change this narrative and make the judiciary a source of pride for all Nigerians. When the legal compass of a nation falters, everything suffers, including public and international perception. The attitude of some of us in the justice sector is sometimes less than salutary, and that has, to a large extent, contributed to the current image deficit of the country's legal system. Forum shopping by some of our legal practitioners is rampant. It is such acts that often give rise to the emergence of conflicting orders by courts of coordinate jurisdiction. I would like to state clearly that henceforth there will be consequences for any act of indiscretion that could bring the judiciary to disrepute. We have rules and ethics guiding the practice of our noble profession, and we must work assiduously to abide by them and always do what is right in the eyes of the law. Under my leadership, the judiciary will adhere to the principles of honesty, transparency, and integrity. I call upon all judicial officers and members of the bar to join me in achieving this goal. The independence of the judiciary is always a topical issue. Let me categorically state that the Nigerian judiciary is independent in conducting its affairs and rendering decisions without interference. At the Supreme Court, for instance, our judgments are free from external influence. While it is essential for the judiciary as a third arm of government to maintain good working relationships with the executive and legislative branches, this should not be misconstrued as subservience. The issue of the salaries of judicial officers, which has for a very long time occupied the front burner of national discourse, has now been addressed through the concerted efforts of many stakeholders, culminating in the unanimous passage of the Judicial Office Holders' Salaries and Allowances Bill by the 10th National Assembly. His Excellency, the President and Commander-in-Chief of the Armed Forces, Senator Bola Ahmed Tinubu, GCFR, gave his assent to the bill on Tuesday, 13th August 2024. With this significant development, we now have in place the Judicial Office Holders' Salaries and Allowances, etc. Act 2024. This significant milestone has empowered every judicial officer in Nigeria to make more meaningful contributions to national development. Nevertheless, it is necessary to continuously review the welfare package to meet changing economic trends and address pressing infrastructural needs of our courts. While current judicial officers may benefit from some of the reforms, those who are transitioning out of service or have already retired are often left without adequate support, especially in terms of health care. The lack of access to proper medical care has had a profound effect on both serving and retired judicial officers, many of whom face severe health challenges with limited assistance. This issue is equally concerning for those who are nearing retirement as they confront the reality of insufficient healthcare provisions once they leave active service. The rising number of deaths amongst serving judges and justices, as well as retired justices and judges soon after retirement, underscores the gravity of this situation. Addressing these gaps by ensuring access to comprehensive health care and improved infrastructure for both serving and retiring judicial officers and staff is crucial to preserving the dignity and well-being of those who have dedicated their lives to serving the judiciary. It is imperative for the judiciary to uphold the tenets of the Constitution which remains the supreme law of the land. The rule of law, as the cornerstone of every functional democracy worldwide, should be strictly adhered to in all our undertakings. We must emphasize the importance of this principle to citizens at all levels, encouraging them to actively walk the path of legality and justice. The rights of every Nigerian must be vigilantly safeguarded against oppression and impunity, utilizing the full array of legal instruments at our disposal. Furthermore, obedience to court orders is non-negotiable. No individual or institution, irrespective of their standing, will be permitted to treat the judgments of our courts with levity or disregard. The judiciary stands resolute in ensuring that the sanctity of our legal decisions is upheld. All hands must be on deck in fostering an unwavering commitment to the full enthronement of the rule of law. Disobedience to court orders or non-compliance with judicial directives is a direct affront to democracy and an invitation to anarchy. As such, it is critical that we respect and observe all the features of an enduring democracy, for in doing so, we maintain the delicate balance that sustains our society. Let us therefore work collectively and tirelessly to ensure that Nigeria continues to abide by the rule of law, upholds the best democratic practices, and remains vigilant in the protection of her citizens' rights. No doubt, the effective administration of justice has always been a pivotal concern in our legal landscape, and recent efforts to modernize the system are crucial in addressing its persistent challenges. Central to these efforts is the enactment of the Administration of Criminal Justice Act, ACJA of 2015, which has been domesticated in various states in Nigeria. However, despite its potential to modernize the administration of justice in the criminal justice sector, key provisions remain underutilized and its full impact has yet to be realized. One major area of concern is the recurrent practice of arraigning suspects in court without proper preliminary investigations. In many cases, efforts to gather evidence are only initiated after trial has begun. This backward approach to criminal prosecution significantly delays the process and undermines the delivery of justice. It is unacceptable that in 2024, we continue to see such practices which contribute to the overwhelming backlog of cases in our courts and ultimately erode public confidence in the justice system. The ACJA, however, provides solutions to some of these problems if fully implemented. For instance, Section 15, subsection 4, mandates that a suspect's extrajudicial statement must be made in the presence of a legal practitioner of the suspect's choice, or where the suspect is unable to secure one, in the presence of an officer of the Legal Aid Council. Additionally, the Act requires that the entire process be video recorded. These provisions are designed to ensure transparency and fairness in the treatment of suspects, reducing the risk of coerced confessions or procedural abuses. Unfortunately, many law enforcement agencies and prosecutorial bodies have not yet embraced these critical safeguards. The failure to adapt these measures exacerbates delays and inefficiencies, resulting in prolonged detentions and frequent adjournments due to inadequate evidence. Full compliance with these provisions of the ACJA would not only streamline the investigative and prosecutorial process, but also enhance the credibility and integrity of the criminal justice system. The effective implementation of the ACJA and ACJLs in the states must be prioritized. Law enforcement agencies, prosecutors, and judicial officers need to be properly trained and equipped to adhere to the requirements of the Act. In addition, mechanisms for accountability must be established to ensure compliance with these provisions. Beyond the ACJA, other critical aspects of our criminal justice system, including reforms in policing, the legal process, and the protection of individual rights, must be pursued with urgency and determination. These reforms are essential to creating a more efficient, transparent, and just criminal justice system that reflects the needs of a modern society. It is my intention to strengthen our processes provide speedy and qualitative administration of justice, reinforce our structures from the Supreme Court to other courts of record, and reduce corruption to the barest minimum in the system. The Code of Conduct for judicial officers will be strictly enforced. Similarly, the requisite ethical standards will be expected of the bar. Staff of the judiciary will also be expected to strictly comply with the Code of Conduct applicable to them. I must reiterate that the task of cleaning the audience table is a collective one, and my commitment to it is unwavering. I assure you that I will pursue it vigorously. The Supreme Court Rules 2024, which came into effect on 1 August 2024, introduced innovative provisions to enhance the efficiency of justice delivery. For instance, the rules provide for an automatic extension of time to file certain processes in the first instance for the same period without penalty, and in the second instance with the payment of a penalty in default. Thereafter, no further extension of time will be allowed except in an appeal against the death penalty. This innovation eliminates applications for extension of time to file processes which hitherto unnecessarily clogged the court's docket. The period provided for the filing and exchange of briefs has been reduced, while greater responsibility is placed on legal practitioners in certain regards to ensure the speedy hearing of appeals. A notice of non-contention must be filed where a party does not intend to contest the grant of an application. Where service of a process is effected on a legal practitioner who has ceased to appear for a party, failure to inform the court expeditiously will be deemed an act of professional misconduct. Furthermore, where costs have been awarded against counsel personally as a result of abuse of court process, he shall file a certificate of compliance within 90 days of the order, failing which he will not have the right of audience in any superior court of record until compliance. Where costs are awarded by the lower court, they must be paid into an escrow account in a commercial bank in the name of the chief registrar. A certificate of compliance duly verified by the registrar of the court below must be compiled along with the record of appeal. Failure to comply shall be deemed as failure to comply with the conditions of appeal with the necessary consequences thereto. We have also made significant strides in modernizing our operations through technological innovations. We have now successfully automated the enrollment unit of the Supreme Court of Nigeria in March 2024. All lawyers called to the Nigerian bar can now enroll online. Prior to the automation of the enrollment exercise, physical presence of all lawyers at the Supreme Court of Nigeria for enrollment was a recurrent feature. However, with the new development, the enrollment exercise has now become seamless and less cumbersome, as it can be done with ease from the comfort of the applicant's respective homes. My lords, distinguished invited guests, ladies and gentlemen, I wish to reiterate that the rank of Senior Advocate of Nigeria comes with immense prestige and greater responsibilities. Those conferred with the rank automatically become members of the inner bar and revered apostles of the Temple of Justice. It is an honor no conferee can afford to take for granted. The Legal Practitioners Privileges Committee painstakingly screened and holistically assessed all the documents submitted by the applicants before arriving at its decision. Even though we know that there is no human system that is infallible, at least concerning the efforts put in place by the committee, I can say with all sense of responsibility that they have done a good job. The 2022 guidelines for the conferment of the rank of Senior Advocates of Nigeria require very high standards of merit from all the applicants vying for the award. Every requirement contained in the guidelines was strictly observed before arriving at the final list. There were 127 applicants for the 2024 exercise. Out of this number, 114 are legal practitioners and 13 are academics. The total number of qualified applicants after the preliminary screening was 98. After conducting the specified screening and filtration exercises, which include a number of appearances in superior courts, recommendations by Honorable Justice of the Supreme Court and Honorable Judges of Superior Courts, Chambers inspection, approval and eligibility and integrity of the candidates from the Nigerian Bar Association, body of senior advocates of Nigeria, and of course the general public among others, the LPPC approved 87 successful candidates who by all standards can be regarded as eminently deserving of the rank of senior advocates of Nigeria. Out of this number, 86 are advocates, while one is from the academia. This is indeed a great feat. On behalf of my learned brother justices of the Supreme Court and members of the Legal Practitioners Privileges Committee, I congratulate the 87 successful senior advocates that have just been sworn in. Your success did not come on a platter of gold. You have worked for it. You deserve every privilege, honor, and pride that comes with it. As senior advocates of Nigeria, you carry on your shoulders a lot of responsibilities. From this moment, your behavior and general conduct will now be publicly scrutinized by all those who come in contact with you. Watch your utterances, watch your actions, and watch your company, as you now have an even higher responsibility to assist the court in attaining justice, equity, and fairness. You must display enormous integrity, self-discipline, leadership, and high standards of advocacy. The conferment of the rank on you today authorizes you to use the letters SAN as a lifetime appellation after your names. Similarly, it has conferred on you the uncommon privilege of wearing the silk gown and full-bottomed wig. In addition, you now have the enviable privilege of sitting at the inner bar of our courtrooms across the country and having your cases mentioned first in all courts. However, you are reminded that the rank of Senior Advocate of Nigeria is a privilege and not a right, conferred after due deliberations by the Legal Practitioners Privileges Committee. It is a privilege that can be withdrawn if it is abused. As holders of the esteemed rank, a higher level of integrity, ethics, and accountability is expected of you. The young lawyers equally need your mentoring and guidance, while the court needs your erudition, advocacy, and positive contribution to effective justice delivery. It is opposite at this stage to note that the review of the requirements of the rank of Senior Advocate of Nigeria will be a continuous process in order to ensure that the highest standards are maintained. The docket of the Supreme Court is unnecessarily clogged by legal practitioners seeking to attain the rank by making up the required number of judgments from the court, whereas many of the appeals do not contribute to our jurisprudence. I also seize this opportunity to comment on the mode of dressing by some of our lawyers, especially the younger ones, which does not reflect the honor and dignity of the legal profession. I must unequivocally state that any lawyer who does not adhere to the prescribed dress code for legal practitioners will not be permitted to appear in court. Such disregard for professional decorum undermines the prestige and global respect that the legal profession commands. I call upon the leadership of the bar to take proactive measures to properly guide and mentor the young lawyers. They must be continuously educated on the essential standards of our profession, especially regarding dress code and ethical conduct. It is equally important to remunerate your juniors appropriately, as fair compensation is crucial to nurturing talent and ensuring job satisfaction. This responsibility is the first task I'm assigning to both the new Senior Advocates of Nigeria and the leadership of the Nigerian Bar Association, which incidentally is assuming its role at the same time as I take up this mantle. I am confident that together we will succeed in restoring the dignity and reputation of both the judiciary and the legal profession in our country. The Nigerian Bar Association has consistently demonstrated its commitment to the pursuit of justice in our nation. The leadership of the association has fostered a strong and mutually beneficial relationship with the bench, and this is highly commendable. On this occasion, I wish to congratulate the immediate past executive for the numerous milestones achieved during their tenure. One notable achievement is the seamless deployment of modern technology to register all participating lawyers across the country for the 2024 Annual General Conference. following the successful online election in July 2024, which resulted in the election of Mazi Afam Osigwe, Senior Advocate of Nigeria, as the 32nd president of the association. This process has once again provided the Nigerian society with a valuable lesson. We are capable of effectively utilizing technology to elect our leaders with transparency and efficiency. I was particularly impressed by the turnout and active participation of legal practitioners at the recently concluded 64th National NBA Annual General Conference held in Lagos in August 2024. The remarkable assembly of such a large number of lawyers under one roof is indeed a noteworthy accomplishment. I extend my heartfelt congratulations to the immediate past NBA President, Mr. Yakubu Mekiao, Senior Advocate of Nigeria, and his team. The quality of resource persons and the thought-provoking papers presented at the conference centered on the theme, pressing forward a national posture for rebuilding Nigeria, have undoubtedly reignited our collective resolve to build a prosperous society. I also extend my warm congratulations to the newly elected President of the NBA, Mazi Afam Osigwe, Senior Advocate of Nigeria, and wish him a successful and impactful tenure. We look forward to continued cooperation and collaboration, building upon the solid foundation laid by the immediate past executive. Finally, I wish to express my sincere gratitude to everyone present today for attending this special session to mark the commencement of our new legal year. I deeply appreciate your presence despite your undoubtedly demanding schedules and the change in time for this ceremony.
Let's take a trip to Rivers State, shall we? The political situation in Rivers State, South Nigeria, is becoming messier and nastier. Confliction judgments delivered by judges over vexed issues in the state are aggravating the tension. As such, the Chief Justice of Nigeria, CJN, Justice Kekere, has summoned judges involved in conflicting rulings on political cases in the state. A panel of the National Judicial Council, NJC, will probe the judges, just as the CJN ordered that the reports be submitted this week. The panel will be headed by a former Court of Appeal Justice. The CJN has also summoned the Chief Judge of the Federal High Court for questioning after formal complaints were filed with the council. Now, Mayor, the CJN summoning multiple judges, for questioning following this issue of conflicting and contradicting court orders. What should we expect?
Let me start by saying that what is happening in Rivers State is an embarrassment. Politicians, judiciary has allowed politicians to mess them up. Okay. And what they're just doing is that each party are just shopping for judgments. Everybody going to different courts to get the same kind of relief. So that we will not have a problem where somebody will say that, oh, these people should not be in the house. Another court will say, oh, this is a faction that is recognized. And judgments, which is an embarrassment actually. And then, but the most important thing is that even some people, that every state has federal high courts. Instead of some of the parties to take their cases to federal high court in their state, they will take it to federal court in Abuja. Who has no business getting involved in the first place?
The issue of jurisdiction.
Yes,
exactly.
who has no business getting involved in the first place? And they've just messed everything up and embarrassed the judiciary. So I'm so happy that this CJN have tried to clear the mess that we have on ground now. And I think she'll be able to do that. Some of these judges, I don't have proof, could have been induced to be given all this judgment that they give. So any judge that has no business listening to or giving a false relief should be disciplined. Should be disciplined. It is important for the CJN to send a message that the era of shopping for judgment is over. It's over. Because that's what politicians, that's what they do. And it's so prevalent in Rivers because the two factions go to different courts seeking different reliefs to suit their purpose. So in other words, you will see a judge of competent jurisdiction giving an order, another court will give another order that is contrary to what has been given. So it's just an embarrassment, and everybody will claim that they are on the right path because they have a judgment.
Exactly.
To that effect. For example, you know, they have two factions in the House of Assembly. There are different judgments that both of them can rely on to be able to do what they are doing. So the CJN, what the CJN has done is very nice, but apart from the fact that she wants to try to clear the mess, judges that have been found to have done what is beneath their position
should
or oath of
disciplined.
office should be disciplined.
Should be disciplined. Still talking about discipline, the CJN Justice Kekere, on her inauguration, if you remember, she said that she was going to discipline Erin, talk about the issue of indiscipline. But if we're to look at it, do you think the CJN can surprise most Nigerians on this matter?
Let me put it this way. To start with, I feel personally embarrassed as an editor when you bring a story from some politicians or politicians making statements and saying that this judge is going to be bribed. They are even anticipating what is going to happen. And I'm like, I can't use this kind of story. That is desecrating the temple of justice in its first place. But their argument is, we have enough facts to tell you that this is what is going to happen. As much as that is subjudice, that is something that we should not preempt the court. But time and time again, we've been proven wrong.
Okay.
That the kind of respect some of us have given to them has dwindled greatly. However, we should look at it from, I don't know whether I should clap my hands for CJN,
okay,
because I've also seen former CJNs also summon some judges who are caught in this kind of thing.
So this is not the first time.
So if Mayor is asking for discipline, I don't know whether we should be very specific. What kind of discipline? Should they be derobed? Should they be barred from the bar? I mean, from the bench? What is the level of deterrence that we should be proposing?
Okay.
Otherwise, somebody might say, after all, if they suspend me for 1 year.
No, not suspension. If you find to have contravened your oath of office, you are supposed to be sent out of the bench.
Beautiful.
That's what you are supposed to do.
They've
done that severally before in the past. So it's just that it's not a common thing, but they've done that. A lot of judges have been sent out of the been derobed because they were found to have put their hands in certain things that they shouldn't have done. So what the CJN is saying is that I want a report about why should these people do that. Exactly. Then there are some judges that have no business getting involved in that. For example, a federal judge in Abuja giving judgments and reliefs to people for a state that you have taken to a federal high court in Rivers. Everybody knows that cannot be right.
Now, let's also look at, still talking about the issue of conflict, let's talk solutions now. Is it possible for us to have like a central database whereby judgments are filed there to avoid some sort of similar judgments? Is it possible?
No. That cannot change anything, because there are records, there are court records that you can access any judgment that was given.
Easy.
So it's easy to do that. The only difference in this one is that if court A gives a judgment seeking, if I go to a court now, if I'm shopping for judgment, and I go to a court and I seek and ask for a relief, and the court grant that relief to say that, oh, this faction of the House of Assembly is the one recognized, then the other party will go to another court and go and seek a relief there, and the court will say, no, these people, they have not been removed properly. So in the face of the law, they are still members of that assembly. So those are the kind of problems that we have. There is no way you can stop that one, because you cannot stop a judge who wants to do something that is illegal to do that. But what you can do as a CJ is to show courage to say, look, a new policeman is in town. I'm not going to accept this, because there's a procedure.
Yes.
If any judge is found to have done something he shouldn't have done or found wanting, the NJC, they will take this case to the NJC. It's just that the problem is that prior to this time, they don't take enough of these cases to the NJC.
Don't report it.
And then we don't really, NJC do not, only 1 or 2 judges that have been trying, but in most cases, they just allow it to slide.
Now, the question of independence of the judiciary now comes to mind. how can we have some sort of transparency and restoration of the judiciary without having judicial independence? Because it looks as if there is politics here. The politicians are just putting their hands. How can we have independence?
So that it doesn't look like an academic exercise. These are people who are part of the system. So when we are dealing with the system, we need to be very clear that the sanctity, the integrity has no other duplicity. If we must sustain the sanctity of the temple of justice, people should look beyond sentiments. And that's why we put that stuff, on the faces that justice is blind to any form of sentiment. It is not about who is involved. It's about what is right and what is wrong. That's what the judiciary stands for. I agree that, okay, there's separation of power and the rest, but the justice probably is a husband of someone who has a case in someone. You understand? So we cannot detach them, but they should be subject to the ethics of their profession. Just like in this job, when we have to say the truth, we have to, damn the consequence and stay on the path of truth. So that's what is expected. For every profession, there are code of conduct, there are professional ethics that are demanded of them. So, and we rate them very high. I'm talking about our judges and our justices. So this must be upheld.
Because when a governor can tell a state high court, a state high court, oh yeah, I want this thing. Will the state high court judge say no?
We can say no.
He can say no. He can say no.
And talking about independence, like
the independence of the judiciary.
Talk about the independence. There's, of course, independence for the judiciary. The only problem they have is that they don't have financial independence.
The financial independence.
That is the problem. So the judiciary is still dependent on the executive to do a lot of things. If they can have their own funds on first line charge, like the National Assembly,
yes,
and the CJN controls the budget of the judiciary,
simple,
not the one that they will just send to them, but the entire money that they need, they won't need the executive. Because the problem now is that they are still beholden to the executive. Though there's an improvement, one of the things you have to give President Bola Tinubu, he did that in Lagos too, is that he has increased the salary of judges by, I think, 300%. Now,
yes,
they've increased their salary by 300%.
Yes. And the
Wiki has started building houses for them. That's the same thing they did in Lagos. In Lagos, apart from building, they were building houses for judges, giving them official cars, and increase their salary. The only way our judges can be independent is if they are financially independent. If they are not so poor that bribe will be attractive to them. If you pay them well and you isolate them from the society, they have a good home and they live well, then it will not be easy
for them
for politicians to manipulate them. Not because there are some good judges who, no matter the circumstance, they are not going to compromise.
They are not going to.
They have the reputation.
But we are pressed for time.
There are some people. Yeah, there are some people that will, of course, there are some judges. They will know that.
But my final question will now be: who should we now blame for this issue of conflicting court judgments? Is it the politicians? Is it the lawyers?
No, it's the judges.
The judges, not the politicians.
No. If a politician comes to you,
yes,
for you to do something that is wrong,
you have a right
that
to
is
say
against
yes or
your
no.
conscience, for you to be a judge that is worth your salt, you should be able to say no. If you pander to a politician and you collect money, you are not worthy to be a judge.
What about the lawyers who bring the cases before them?
It doesn't matter.
They should not be blamed.
No. The lawyers, they are doing their job.
They are doing their job.
Yes, if I have a case, I can go to court and try to play on technicalities. It is within the purview of lawyers.
Right, let me put it this way. I don't know whether you're a football fan.
Yeah, I am.
It's like a player deciding to carry the ball in his hand and decide to throw it inside the net. The referee should say this is foul.
Yes.
And you're given a red card.
Yes.
So it's not a matter of, they are converting the system. And quickly on what you just said.
Yes.
The way out is just to, and I just want to quickly buttress the point he made, is the fact that even if they are given 500% increase, it is not a favor. It is for them to do their job without being influenced.
Without being influenced.
Do you understand what I'm saying? As much as we'll give all the kudos to executive arm,
yes,
it's for them to understand that the way out is still this first line charge. Let them have that financial autonomy. When they have it, they decide what is okay. Because they are humans and they can easily pander towards those who are in power. All
right, thank you.
And another thing is, if those who are in power wins a judgment, it does not mean it is one-sided. It can go either way. That's justice.
Either way. Anyway, thank you so much, gentlemen. Mayor Kimberly, thank you very much for having this conversation. And also, Kaidi Ladende, appreciate you as always.
Thank you so much.
And I want to say a big thank you to the gentlemen, the PCR and the MC.
This is coming after several lamentations from illustrious sons and daughters of Nigeria over the conflicting judgment consistently be given by the nation's judicial system on political matters. Of course, you will agree with me that this is timely, and the CJN will expect you to do the needful. The judiciary is no longer the hope of the common man. You people has continued to compromise and rubbish the system, which is not good for the image of the nation's judiciary. Sometimes, when your legal colleagues give certain judgments, even laymen on the street now begin to bow, now begin to be surprised, astonished by the rascalities people display at the front of your profession. The rascality currently happening in the nation's judicial system is worrisome, extremely worrisome.